Folks, it's 9:30. Commissioner Janeka ran into a little delay, so we're going to give him a few minutes. I apologize for the delay, but we'll get going here in just a little bit. Well, good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, October 5th, 2022. The time is 9:35 a.m. With us today are Commissioners Emily Lindley and Bobby Janeka, as well as our General Counsel, Mary Smith, and I'm John Neerman. For those of you who are joining us virtually, I'd like to ask you to please keep your microphones muted when you're not speaking. For those who are making presentations, we will inform speakers of their time limits. We'd ask you to wait to begin speaking until either our General Counsel or I ask you to do so. Registration is now closed, but if you'd like to address the Commission on a particular item, please email agenda@tcq.texas.gov with your name, your affiliation, and the item you'd like to speak to, and we will do our best to accommodate that request. With that, I'd like to thank everybody for being present, and Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by the City of Granbury for new Texas Pollutant Discharge Elimination System permit number WQ00158210001. Only the parties may address the Commission in this matter, but I wanted to acknowledge that there are quite a few people signed in and let them know that you will be noted, your presence will be noted for the record. The order of presentation for this item will begin with the applicant, followed by the protestants, the ED, and OPIC in that order. The parties have been notified that they will each have 5 minutes of oral argument time. The applicant may save time for rebuttal as it bears the burden of proof for this application. And with that, we would call the applicant's representative, Mr. Jason Hill.
Good morning, Mr. Hill.
Good morning, Mr. Chairman. Good morning, Mr. Chairman, Commissioners.
And Mr. Hill, can you make sure, do you have a green light on that microphone? We may need to turn the volume up a little bit for you so you can be heard, but
Good morning. There we go.
we've got it.
All right. Mr. Chairman, Commissioners, I'm Jason Hill here on behalf of the City of Granbury. I've reserved a few minutes for rebuttal if it's necessary, so I'm going to get with it. What you have in front of you, Commissioners, is a full, robust, complete application for a discharge permit by the City of Granbury. The application was submitted over 3 years ago. Since that time, the world has changed. The City of Granbury has experienced tremendous growth over the years. One thing that hasn't changed during that time is that growth projection. And in fact, what we've seen over the last few years has exacerbated the growth as opposed to throwing water on it. With that growth comes challenges to infrastructure and strain, and the City of Granbury has put a plan together to address those, and this permit is a substantial component of that plan to address the city's infrastructure challenges. There were 13 issues that the Commission referred to SOA for the parties to address in a contested case hearing. They were a comprehensive set of issues. They raised issues that are front and center in front of this agency, but what you have in front of you is a full record. We had 8 witnesses for the City of Granbury, 8 of whom were experts. None of their credentials were challenged in this case. You will see in the record that there is above a preponderance of evidence that supports the administrative law judge's proposal for decision and the findings that they lay out in their proposed order, both through the prima facie demonstration as well as direct evidence that was offered in the record. Commissioners, you'll find in the record that the executive director, the agency staff followed the executive director's procedures in every step of the way through their review of the application. Their technical review is not only defensible, it was defended by an overwhelming weight of evidence into the record. In addition, the evidence that was offered in the hearing, both by the executive director and the agency staff, demonstrated compliance with all the requirements and satisfaction of each of the questions that was raised and the issues that were referred. Commissioners, I've got time reserved for rebuttal, but I want to ask you to consider adopting the proposed order that the administrative law judges have drawn up and acknowledge and accept, rather, their analysis of the issues that led ultimately to their findings. Thank you.
Thank you, Mr. Hill. And we'll hear next from the protestants. Good morning, sir.
Good morning. Mr. Chairman, Commissioners, General Counsel, my name is Michael Booth, and today I'm representing my clients, The Risk and Bennett RV Ranch and Granbury Fresh, in this oral argument. I'm just going to start and say the evidence was lacking because key water quality evidence was excluded by the ALJs, and I'll talk about that in just a second. But I want to say that this case started because the city of Granbury located this plant without consulting environmental water quality experts as well as an environmental attorney, because they were hired after the draft permit was granted. And so a lot of this was hurried, and sadly, we probably didn't get as good a record developed as we needed. But we're here really to talk about a few policy questions and some evidence that was lacking. And the first is it's undisputed that there is a unaerated equalization basin within 100 or within 500 feet of the property line. In fact, it's right probably 200 feet. The city located or wants to build this plant on a very small site, and they're abutting it right next to my property, my client's The Risk's RV park. There's pictures and diagrams in the record I'm sure you looked at. Well, there was a lot of dispute about what was an anaerobic and not, but the rules say if it is a unaerated equalization basin, then it has to be within, the buffer needs to be 500 feet. The staff, when they evaluated this, said if the applicants said that the property would be, the wastewater would be in the equalization basin for less than 48 hours, then it was okay for them. There's another unit called a BNR reactor that is also an unaerated equalization basin, and that's going to be located within 500 feet of the property line. So we're saying the rules don't give you any, and in that instance, the staff said as long as it wasn't allowed, the water wasn't allowed to go septic, then it was okay. That's not in the rules. The rules say 150 on units, 500 if it's unaerated equalization basin, or other things of that nature that would have go anaerobic. All right, the modeling, the OPEC agrees that the modeling lacked, and there weren't any, with one exception I'll talk about in a second, the findings of a dissolved oxygen of 5 DO. All of them were less than 5 DO. The staff and the applicant think you could have 4.81, and that's close enough for, as the saying goes, government work. Well, it's not. You say 5 in your rules, not 4.81. And on top of that, what we found is that the default model has a standard elevation and barometric pressure, really, and that wasn't what we had at Granbury. So our expert corrected for that, and he got 4.01 or something like that, way below this 4.81. This is all set out in the briefs, and I'm sure you've read it, but where we end up with that there's one model that showed a higher number, and the applicant went back and tried to calibrate Quality X is the model that we're talking about. I'm sorry to mention that, and the problem is, and that got 4.95. The problem, that model, they didn't change the reaeration rate, and so that would really cause a problem. In fact, their experts said it might even be below 3. Well, so we don't think there's any evidence showing 5. But what we did want to do, and we tried to put on rebuttal of our expert, and it's offered in the record as under an offer of proof, and our expert has way below 4.81. Y'all could see what he said. The judges did not let us do that, even though the modeling wasn't complete until after our pre-filed was due. And they wouldn't let us have rebuttal, and so we think that that's an error in and of itself. There's another issue that we think is important. Well, there are other issues in there that we thought were valuable to be discussed, but we think that the anti-degradation analysis on Tier 2 was inadequate. And when
That's fine.
Pardon me? 2 minutes, was that 2 minutes? Or
I think
five?
she was calling 5 minutes, but
Okay.
please
I'll finish
finish
that
your
thought real
thought.
quick.
Finish your thought,
Okay.
sir. Thank you.
The way that the executive director does the analysis, they look at these tables and they used a volume of water that they were looking at the phosphorus nutrient loading of the Lake Granbury. Well, it's not. It's the Rucker Creek Cove. And so it went from 2.09 phosphorus loading increase to 625 phosphorus loading within the Rucker Creek Cove and Rucker Creek Creek. And so we would ask the commission to deny this permit. And I'll answer any questions at the appropriate time.
Thank you, Mr. Booth. Colleagues, any questions for Mr. Booth? Seeing none. Thank you, sir. Let's hear next from the Executive Director's Office.
Good morning. Can you all hear me okay?
We
Great.
can. Thank you.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Anthony Tatu from the Environmental Law Division, and I have with me at the table this morning Gordon Cooper and James Mayhawk from the Water Quality Division. And we're all here on behalf of the Executive Director. The Executive Director supports the Administrative Law Judge's proposal for decision and the proposed order. We would respectfully recommend that the Commission adopt the proposed order, grant the application, and issue the permit to the City of Granbury. We are available for any questions you may have. Thank you.
Thank you, Mr. Tatu. Colleagues, any questions for Mr. Tatu? Seeing none, let's hear next from the Office of Public Interest Counsel.
Good morning, Chairman and Commissioners. Garrett Arthur for OPIC. As stated in our closing brief, OPIC found the City of Granbury met its burden of proof for most of the referred issues. However, the city failed to meet its burden of proof on issues G and I. Issue G asks whether the modeling complies with applicable regulations to ensure the draft permit is protective of water quality. OPIC finds the weight of evidence indicates that the modeling for dissolved oxygen does not ensure the draft permit is protective of water quality. Issue I asks whether the nutrient limits in the draft permit comply with applicable Texas surface water quality standards. OPIC finds that the draft permit's total phosphorus limit should be lowered in both phases, and a total nitrogen limit should be added to the draft permit. Our position is based on discharge volume, discharge route characteristics like critical low flow and short length, the limited dilution that occurs prior to and in Rucker Creek Cove, and the primary contact recreation and public water supply uses of Lake Granbury. The city's failure to meet its burden of proof on issues G and I is a basis to deny the application. However, if a permit is to be issued, OPIC respectfully suggests that the total phosphorus limit be lowered in both phases, and a total nitrogen limit should be added. Finally, if the proposed order is to be issued, OPIC concurs with the corrections identified in the ED's exceptions. Thank you.
Thank you, Mr. Arthur. Colleagues, any questions for Mr. Arthur? All right, and the applicant has reserved some time for rebuttal. Mr. Hill, you're up again.
Thank you, Commissioners. Let me just say right off the bat that the city's Tier 2 anti-degradation review was one of the most comprehensive reviews that I've ever had the privilege of working with. The experts that were involved left no stone unturned on this issue that really has become a paramount issue in the state of Texas in water quality permitting. The assessment included site-specific collected data that was used in sophisticated modeling to make predictions of potential water quality impacts, and all of that data combined demonstrated that the discharges that would be authorized in the draft permit would not lower water quality by more than a minimus extent. That evidence is largely unrefuted, and none of the credentials of any of the experts that were involved in that assessment were challenged. In fact, they're unchallengeable. With respect to the issue of the buffer zone, the ALJs covered that issue, and they saw through the argument. The really unimpeachable testimony by some of the city's expert witnesses on that issue and how the system is designed to work, how the system will work, demonstrates that the proposed facility will comply with the 150-foot buffer zone. And the really no evidence to the contrary, just argument. The ALJ saw through it. I think the rationale and their analysis of that issue is spot on, and I think the findings that they made in response to that issue based on that rationale is fully supported by the evidence. And with regard to the modeling, the protestant's primary witness with regard to the Qualtex modeling had been thoroughly discredited independently, not only by the city's expert witness, but also by the executive director's expert witness, independent of one another, came to the same conclusion that the veracity of his testimony on that issue was not supported by what the true evidence showed in the case. Commissioners, in addition to the city's satisfaction of the Tier 2 requirement to show no degradation of water quality because of this permit, the city has also offered a proposed finding that I think is reflective of the evidence that's contained in the record as well. It's undisputable that this permit, this facility, is necessary for important economic and social issues in the city of Granbury and the region. And without it, the economic consequences of the inability to have this additional treatment capacity are dramatic. And perhaps that's an understatement if you saw the evidence that was presented into the record. Commissioners, the city of Granbury respectfully requests, based on the the administrative law judge's assessment of the evidence, their analysis, their proposed findings of fact, that you adopt.
That's 5 minutes.
Go ahead and finish your thought.
Administrative law
Mr.
judge's proposed findings of fact. You issue the draft order. You include the additional finding that the city of Granbury offered in its brief on the proposal for decision, and you issue the permit as it's drafted. Thank you, Commissioners.
Thank you, Mr. Hill. Colleagues, any questions for Mr. Hill? Seeing none. Thank you, sir. Quite a few issues on this item. I reviewed them carefully. The arguments are very familiar that we heard this morning. I do not see a reason to second guess the ALJ's evaluation of the evidence. So that's my view. Commissioner Lindley, what's your take?
I'm in agreement. I would be comfortable adopting the proposed order with the, exceptions, or regarding the few findings of facts that we can talk about if we want to, but I'm fine, supportive of it.
Commissioner Janeka.
I'm also in agreement, and I have one question that I would like to try to revisit now that we've heard from all the different parties, and that's on the point that OPIC raised on a total nitrogen limit rather than, and I think posing the question first to ED staff might be appropriate. I wonder if they may speak to the practicalities or the reasonableness of whether it's necessary to have a total nitrogen limit and total phosphorus limit. If do we reasonably expect those two factors to align closely enough that it's what's the agency's view on it?
Typically, total phosphorus is the limiting nutrient in fresh water. There can be situations in very low nutrient streams where nitrogen can become a limiting factor when phosphorus becomes available, but typically in larger water bodies, lakes, reservoirs, total phosphorus would be the limiting nutrient.
I appreciate that, and that affirms what my general understanding was, and I take it that executive director staff is very prepared to recognize those unique water bodies where that might be the case and would consider the appropriate limit. And just wanted to return to the points that OPIC raised specifically. I think that's a worthwhile point in this permit to point to, but I'm not concerned given the way that we understand those factors to operate and interplay with these permits and these facilities in the environment. So I do appreciate you raising those points, but I'm comfortable moving forward.
All right. I guess we just, should note that there were a few findings of fact, 17, 25, and 86, that the ALJ's July 26th letter addressed, and
Yeah.
so I think those should be included in any motion if we're ready for a motion.
I agree. That's what I was mumbling when I was mumbling, alluding to. I apologize for that. But I have a motion, and I would move that we adopt the ALJ's proposed order as revised by the ALJ's letter dated July 26, 2022 regarding findings of fact numbers 17, 25, and 86, that we issue the ED's draft permit, and that we adopt the ED's response to comments.
Second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2. Give everybody a chance to come up.
Give it just a moment.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order assessing administrative penalties against Javal Ventures Incorporated doing business as Mako Collision Repair and Auto Painting. The order of presentation will begin with the ED, followed by the respondent, and then OPIC. The parties have been notified that they will each have 5 minutes of oral argument time. The ED may save time for rebuttal as the ED bears the burden of proof.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Jennifer Peltier with the Litigation Division, here on behalf of the Executive Director. With me this morning is Donna Chafin with the Financial Administration Division, and online is Warda Omar with the Houston Regional Office. This enforcement case involves an auto body refinishing shop owned and operated by the respondent, Javal Ventures, Inc. The ED alleged 6 violations against respondent for failing to comply with the terms of its permit by rule. The ED recommended a penalty of $13,875 and did not seek corrective action because respondent no longer owns or operates the auto body refinishing shop. Respondent asserted the alleged violations had been resolved and that it does not possess the financial ability to pay the penalties. In the PFD, the ALJ found the ED proved the alleged violations. The parties stipulated that if violations were found to have occurred, the administrative penalty was calculated correctly. The ALJ also found respondent waived its financial inability to pay claim because it did not meet the burden of proof to show it would qualify for a deferral in the administrative penalty for failing to produce all financial records potentially relevant to the issue. The ED filed exceptions to address minor corrections to the proposed order. The other parties did not file exceptions nor responses to the ED's exceptions. The ALJ's August 29, 2022 exception letter agreed with the ED and recommended adoption of all of the ED's recommended changes to the proposed order. The ED agrees with the ALJ and respectfully requests you adopt the ALJ's proposed order as amended by the ALJ's exception letter. And with that, I would like to reserve the remainder of my time. Thank you.
Thank you, Ms. Peltier. And we'll hear next from the respondent. Mr. McBogie, are you with us? There we are. Good morning, sir. And I'll ask you just to make sure that there's a green light on that microphone, and then you can go ahead when you're ready.
Okay.
And we hear you.
Good morning, Mr. Chairman. Good morning, the commissioners. Honestly, I feel very odd standing here. I'm not a lawyer. I'm just here to plead for mercy, to ask for leniency. I used to own a body shop, which I started in 2017 with my 401k in a program known as Rollover for Business Startup. So I had that going, and until the pandemic hit, everything went down. And 2021, the franchise was taken away from me by Mako Corporation. So I don't own that anymore. As I stand here, I'm looking for a job. So when this thing came on, I tried to explain. I followed up by saying, one, I didn't have the money to get a lawyer to represent me. I didn't have the money to produce all the financial documents that were being asked of me. And I stated that even when that was on, I think the financial division looked at it and said, well, he said he didn't have the money to produce the financial documents. So if I have to go back to talk about what happened, I complied with what was required. I guess neighbors called, they said they perceived some order. But when the inspectors came, they didn't observe that. But in the process, they saw some housekeeping issues, which they asked me to take care of, and I did. So in a nutshell, I'm not here to fight anything. I'm just here to ask for mercy. I don't have the money to pay for that. If I had the money, I would hire a lawyer. I would produce the financial documents they were asking for because I needed to see a CPA. So in a nutshell, that's what I have here. Thank you.
Thank you, Mr. McBogie. Colleagues, any questions? Thank you, sir. Let's hear next from Mr. Wayne. Good morning.
Hey, good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, Attorneys, and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. OPIC supports the proposal for decision and agrees with Judge D'Angelo that the Executive Director adequately proved that respondent committed the violations as alleged in the Executive Director's First Amendment report and petition. Further, OPIC notes that the parties stipulated that the proposed penalties were calculated correctly, and OPIC sees no reason to contest that stipulation here. Therefore, OPIC finds that the penalty recommended by the Executive Director is reasonable and calculated in accordance with applicable statutes, agency rules, past agency practice, and the TCEQ penalty policy. Additionally, OPIC agrees with the judge that respondent waived his claim of financial inability to pay because he did not provide all necessary financial records. Finally, OPIC concurs with the recommendation of the Executive Director that because the facility is no longer in operation, the payment of the administrative penalty will resolve this case and no further corrective actions are necessary. Therefore, OPIC respectfully recommends that the Commission adopt the proposal for decision and, consistent with the judge's recommendation, sustain and incorporate the changes requested by the Executive Director in his August 15th exceptions to the proposal for decision. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. Colleagues, any questions for OPIC? Seeing none. Executive Director has a rebuttal. And maybe if you could address one thing I'm curious about is the notion raised by the respondent that somebody who may have a financial inability to pay has to pay a CPA to develop documents, if you're in a position, or anybody from staff is in a position to talk about that. I mean, he's suggesting a catch-22, but
Donna Chapin from the Financial Administration Division can come up and speak to that more specifically, but the requested documents, we do not believe required a CPA to produce. He did not produce financial statements from 2000, 2018, 2019, 2020, or 2022. He did not file quarterly reports filed with the Texas Workforce Commission, note agreements, and the schedule of indebtedness for outstanding loans. Just regular bank statements and information about deposit accounts were not provided to the ED. A list of company vehicles and corporations' ownership structure and the shareholders and corporate affiliates were not provided to the TCEQ.
thank you. Ms. Chapin, do you have anything to add to that?
Yes, because of the failure to submit information about deposit accounts, loan accounts, failure to provide the disclosure form that would allow us to contact any financial institutions to verify reported accounts, loan accounts and deposit accounts, although he didn't report any, he failed to provide information about any existing deposit or loan accounts. Some of the discrepancies that we saw in the information provided, we could not make a determination as to whether there were excess assets that would be potentially able to pay the penalty. We could not determine the respondent's financial position due to the lack of information that he provided.
Thank you for that. Anything else by way of rebuttal?
No, thank you.
Okay. Colleagues, any questions for the Executive Director? Okay. Mr. McBogie, I am very sympathetic to your situation and your business losses. That's, we could all imagine that happening, and we're sympathetic. As you can imagine, we often have regulated entities, individuals coming to us claiming an inability to pay, and so we've developed some very specific and exacting rules around that, and it is exceedingly rare that we make exceptions to those, and I don't see an argument to make an exception here either. I'm sympathetic, but I think we do need to follow our rules. Those are my thoughts. Colleagues, do you have anything to add or other thoughts?
No, I think that was very well said, and I would be supportive of adopting the ALJ's proposed order.
Commissioner Ginecca.
I'm in agreement. And I will make the motion that we adopt the Administrative Law Judge's proposed order with the modifications proposed in the Executive Director's August 15th, 2022 exceptions and proposed order, and agreed to by the Administrative Law Judge in her August 29th, 2022 reply to exceptions.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the application by the City of Corpus Christi for water use permit number 13676. The parties have been notified that the commission will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, as you know, we review requests for contested cases on water use permits under Chapter 55, Subchapter G of our rules. So we're looking for affected persons. We do not necessarily need to identify referable issues. And the heart of the affected person analysis is whether the requester is affected in a manner different from the general public and has articulated personal concerns that are relevant and material to the application. We have numerous requests on this item. Just to cut to the chase, none, in my view, have met the requirements to be granted a hearing. And there are two main points of failure as I saw them. The first is that the requesters failed to identify how they are personally affected, that is, how they're affected in a manner, in a way that's different from the effects to members of the general public. And the second point of failure is that the issues raised were in several cases outside of our jurisdiction on this type of an application. In other words, they're not relevant and material to this application. So for example, concerns about the cost of the facility, the quality of the water that it might produce, environmental equity, the discharge, the effluent discharge and its effects, cumulative effects of nearby facilities, the effects on indigenous lands, the question about power consumption, all of those issues are outside of our jurisdiction on a water use application. In terms of personal concerns, they have to be closely tied directly and with specificity to the proposed withdrawal of water in the bay. So for example, one requester expressed concerns about his business and recreational interests, but didn't state how the withdrawal of water would impact the business or recreational interests. There were several others who claimed recreational interests, and they similarly failed to demonstrate how they would be affected in a manner different from the general public. And then again, several requesters simply failed to identify personal concerns. They identified generalized concerns. There were two associations that requested a hearing. Neither of them identified an individual who would have standing in their own right, so we're compelled to deny those requests as well. So that's how I saw this one. Commissioner Lindley, what do you think?
I'm in complete agreement. I came down on denying all the hearing requests.
Commissioner Janeka?
Likewise and well said, because this is a water rights application, I really think that shrinks the universe of potential affected persons. You wouldn't expect to see impacts shared across everyone across the water body. It really, if you don't have a water right and argue your impact that way, it's a much smaller geographical input tied to that intake, and I didn't see that in the requests.
Sounds like we're ready for a
I
motion.
say I can make a motion.
Yeah.
I would move that we deny all hearing requests and issue water use permit number 13676 to the city of Corpus Christi.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the application by Rattler Ridge LLC for new TPDS permit number WQ00160490001. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
So here we have a Senate Bill 709, House Bill 801 hearing request on a new TPDS permit. So we're back to our familiar two-part analysis. First, we need to identify whether there are any affected persons, and if so, what the referable issues are. And we had one requester in this case, the city of San Marcos. The proposed facility is within the city's ETJ. I think the city made a pretty compelling case that it is indeed an affected person. It will be affected in a manner different from the general public. The city also identified several relevant and material issues on this type of an application, and the ones that I identified relate to the policies on need and regionalization, the anti-degradation review, protectiveness with respect to the health of the city's citizens, with respect to livestock and wildlife, protectiveness of surface water quality and existing uses, and protectiveness of groundwater. They also preserved whether the compliance history should be a factor in this application, whether there are adequate protections against nuisance, and then finally, whether the information provided in the application was sufficient. So I would grant the city's request and refer those issues.
I'm in agreement.
I think that captured all my issues, and I've got a motion prepared.
Great.
I move that we grant the hearing request of the city of San Marcos, and that we refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code 26.0282 and the general policy to promote regional or area-wide systems under Texas Water Code 26.081. Issue 2, whether the proposed discharge will violate TCEQ's anti-degradation policy and procedures. Issue 3, whether the draft permit is protective of livestock and wildlife, including endangered species and aquatic vegetation in the city's ETJ in immediate vicinity of the proposed facility and discharge route. Issue 4, whether the draft permit is protective of the health of the city's citizens in the immediate vicinity of the proposed facility and discharge route. Issue 5, whether the draft permit is protective of water quality and existing uses in the receiving waters under the applicable surface water quality standards in 30 Texas Administrative Code, Chapter 307. Issue 6, whether the draft permit is protective of groundwater in the area. Issue 7, whether the applicant's compliance history for the previous 5 years raises issues regarding the applicant's ability to comply with the material terms of the permit that warrant altering the terms of the draft permit. Issue 8, whether the draft permit complies with applicable requirements to abate and control nuisance odors as set forth in 30 Texas Administrative Code 309.13. And Issue 9, whether the applicant submitted adequate information to support the issuance of the draft permit. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued, and finally, that we deny the requests for reconsideration.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the adoption of 4 draft total daily loads, or total maximum daily loads for indicator bacteria in tributaries of the Neches River below Lake Palestine. The executive director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Kerry Neiman with the Water Quality Planning Division in the Office of Water. Today with me is Nicole Hall, the Total Maximum Daily Load Program, and Stephanie Skogan of the Environmental Law Division. Today, the Executive Director is respectfully requesting the consideration of final adoption of 4 total maximum daily loads for indicator bacteria and tributaries of the Neches River below Lake Palestine. The TMDLs cover 4 assessment units and 4 water bodies within Angelina County. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL document. The development of the document included an active public participation effort and balanced stakeholder group coordinated by TCQ and the Texas Water Resources Institute. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop the document to improve water quality in their community. The Executive Director respectfully requests the adoption of the total maximum daily loads. Permission is also requested to make non-substantive and clerical corrections. Thank you, and we're available to answer any questions you may have at this time.
Thank you, Mr. Neiman. I have none. Colleagues, any questions?
No.
Ms. Smith, has anybody signed in to speak?
No one signed in.
Mr. Arthur, what do you think?
Chairman, OPIC supports adoption of these 4 TMDLs.
Thank you. I do too. We appreciate the stakeholders' work on this. I think it was so good that there was nothing left to comment on, so we received no public comments on it. So, colleagues, I'm certainly ready to move forward.
As am I. I've got a motion. I would move that we adopt the 4 draft total maximum daily loads for indicator bacteria in tributaries of the Neches River below Lake Palestine as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which is items 6 through 19, and the Executive Director's staff is here to present these items.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish of the Enforcement Division and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you, items 6 through 19. The total assessed administrative penalties are $136,717, with $31,749 deferred, $23,275 applied toward supplemental environmental projects, and $81,693 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Any questions, colleagues?
No, thank you.
Seeing none. Ms. Smith, is anybody signed in to speak?
No one is signed in.
Mr. Arthur?
OPIC recommends approval and issuance of these enforcement orders as proposed by the ED.
Thank you. Colleagues, I'm ready to move forward.
As am I.
Likewise, and I move that we adopt items 6 through 19 as recommended today by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
Items 20 through 23 are the consideration for adoption of new subchapters E, F, and G of 30 Texas Administrative Code, Chapter 112, and the consideration of the adoption of the Howard County, Hutchinson County, and Navarro County Attainment Demonstration SIPs for the 2010 Sulfur Dioxide National Ambient Air Quality Standard. The Executive Director's staff are here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Allison Stokes with the Air Quality Division. With me is Terry Salem with the Environmental Law Division. For your consideration today is item 20, the rulemaking to amend portions of 30 Texas Administrative Code, Chapter 112, Control of Air Pollution from Sulfur Compounds, to provide control measures to attain the 2010 sulfur dioxide, or SO2 standard, in the Howard, Hutchinson, and Navarro SO2 non-attainment areas. Also for your consideration today are items 21, 22, and 23, the state implementation plan revisions addressing attainment demonstration requirements for the 2010 SO2 standard in the Howard, Hutchinson, and Navarro non-attainment areas. Staff respectfully requests adoption of the changes to 30 TAC Chapter 112 and the Howard, Hutchinson, and Navarro attainment demonstration supervisions. Thank you, and we're available to answer any questions.
Thank you, Ms. Stokes. Colleagues, questions for Ms. Stokes? Ms. Smith, is anybody signed in to speak?
We have somebody signed in who doesn't want to address the commission, but otherwise no one signed in to address the commission.
Okay. OPIC.
Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, Attorneys, and staff. I'm Pranjal Mehta on behalf of OPIC. Our office has reviewed this rulemaking and SIPs. OPIC agrees that these rules are intended to make enforceable the emission rate limits and associated control requirements, as well as accompanying compliance obligations that are needed to demonstrate attainment of the 2010 sulfur dioxide national ambient air quality standards. OPIC also agrees that the public in the non-attainment area and possibly the surrounding area would benefit from the improved air quality due to lower sulfur dioxide emission levels resulting from the implementation of the control strategy in the SIP revisions. OPIC supports adoption of rules and SIP revisions. Thank you.
Thank you, Ms. Mehta. Colleagues, I think I'm ready to move forward with this with one little asterisk. I was concerned, and I'll give ED staff an opportunity to comment if they'd like to, about, and this may have been inadvertent, but about a waiver of certain process for applicants, AMOC applicants. And the way that I was reading it, it would include a waiver of public notice and comment, and I can give you specific citations if that would help. But the upshot of it is that I don't think we should waive the public participation requirements. And what I'm looking at are proposed sections, and this is all in Chapter 112, so it's 112, 102, I2B, 112, 232, K2B, and 112, 302, C2B. And those sections reference three other sections, and I'll read those to you. 112, 102, I5, 112, 232, K5, and 112, 302, C5. And I can give you a minute to take a look at that, but I think the way that I read that, the upshot is it makes it possible for somebody to avoid public notice and comment. And I think we probably should have notice and comment on that.
This is Terry Salem. I have one clarification. So you would, for example, want to change the language in 112, 102, I2B to delete the reference to paragraph 6 of the subsection.
Exactly. Thanks.
I'm supportive of that amendment.
I am as well, and to put it into very layman's terms, that suggests a possible degree of flexibility that may go past some clear thresholds we expect to see, notifying the public on significant actions. This would remove what, I don't have a lot of concern that ED staff would receive a request like that and act on it without really considering the context, but reading it on its face, right now, looking forward, it does provide a little more, I appreciate that, yeah.
I would have some concern, because I can imagine an applicant coming in and saying, hey, Executive Director, read your rules. So I think we need to just make it abundantly clear. I think we may be about ready for a motion, unless Executive Director staff had anything else to add. Okay.
I can attempt a motion then and see
Okay.
if I
Great.
capture it. I move that we adopt the attainment demonstration SIP revisions for the 2010 SO2 Howard County, Hutchinson County, Navarro County non-attainment areas and new subchapters E, F, and G of 30 Texas Administrative Code, Chapter 112, with the following revisions. Amend proposed sections 112.102 I2B, 112.232 K2B, and 112.302 C2B to remove reference to proposed sections 112.102 I5, 112.232 K5, and 112.302 C5.
Excuse me, you said remove K5, but I think what you meant was 6. Subsection 6 is the public notice provision. Subsection 5 is process.
Let me pause for 1 second.
Yeah.
Before we make the motion and double check.
Thank you for that, Ms.
Would you
Salem.
double-check?
We're going to have a little, I'm going to need a sidebar. I imagine my colleagues might need that also.
Should we recess for a moment and we can that'll give OGC a chance to take a look at that more carefully
Sure.
too.
Yeah, why don't we take a
Thanks, Terry.
Thanks for pointing that out. Why don't we take a 5-minute recess? The time is 10:28, and we are in recess. All right, we're back after a short recess. The time is 10:33, and here's what I think I figured out. I think subsection 6 refers to the formatting of the notice, and 5 refers to the process generally, so that we in fact intend to remove the reference to the subsections 5 in those different sections. Does that make sense?
So which procedure within 5 do you wish to delete?
I think we are proposing to simply delete all of the procedures.
And to clarify, delete the procedure from the waiver.
Right.
Not delete the procedure from the rule, but
So-
from the ability to be
Okay,
waived.
So we're just removing the reference to those sections.
Okay, so then if I'm understanding you correctly, you want to remove the subsection 112.102 I2B completely?
No, we're going to amend that subsection to remove the reference, for example, in that case, to 112.102 I5.
Okay, so you want to leave the ability to request a waiver for public notice format then?
I think that becomes moot, and maybe what you're suggesting is that there will be this appendage in there that's unnecessary, and it's going to make the rule, it's going to create a problem for clarity with the rule.
Yes, it
So
will.
we could, we have a couple of different options. I guess we could
We
continue
didn't
this.
second the item, so I mean, we could,
We could just continue the item to the next agenda
No.
to have time to work
to
this
have
out.
time.
We don't have time to do that. Okay. Okay.
Yeah.
I imagine where this is going is we'll end up, striking the unnecessary language just so we have a rule that not only works mechanically, but that's clear. So,
sounds good.
time's 10:35. We're going to take another recess to sort that out. We are in recess. All right, folks, it's 10:39. We're back after a short recess. And I think there's some more maybe wordsmithing that we need to do on this particular rule. So I'm going to continue it, not to the next agenda, but just momentarily. Mr. Mitchell has been waiting very patiently, I believe, to offer public comment, and I appreciate your patience, sir. What we're going to do is go ahead and call your item, and that way you don't have to stick around for our, unless you want to, for our needlework on this rule language. So Ms. Smith, would you please call item 24?
Item 24 is our public comment session. The commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permit matters or other contested cases which are subject to the ex parte provision found in Texas Government Code Section 2001.061. And in the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Please note that the commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response and the recitation of existing policy. First, we have Mr. Stan Mitchell, and we do have one other person signed in virtually.
Okay, Mr. Mitchell, good to see you. Thank you again for your patience, and go ahead when you're ready, sir. And you might check the mic, make sure you have a green light.
Now.
We got you.
I'm not as green as I was last time. Good morning, commissioners. Thank you for your service. My name is Stan Mitchell. I'm from San Antonio. There have been 3 major developments since my September 7 presentation, which requested, quote, that you probe the ongoing cover-up by SAW's CEO Puente, ex officio SAW's board member Mayor Nierenberg, and other Vista Ridge LLC adherents, close quotes. First of 3, you have my August 10th, 2022 letter to Amy Hardberger, Esquire, newly appointed Director, Texas Tech Center for Water Law and Policy, and a San Antonio Water System trustee. Trustee Hardberger holds bachelor's and master's degrees in geology and is a registered geoscientist in Texas. Her father, Phil Hardberger, was San Antonio mayor from 2005 to 2009, serving as an ex officio trustee of the 2 city-owned utilities, SAWS and CPS. As a SAWS trustee, Attorney Hardberger is an insider. Hardberger stated at the August 3rd, 2022 SAWS Board of Trustees meeting, quote, "We don't know how long recharge of the Vista Ridge sand aquifers will take. A lot of that modeling was not revealed during the Vista Ridge discussions," close quote. Was not revealed suggests that other information cited here was also withheld from SAWS trustees. SAWS trustee Hardberger, an attorney who teaches water law and policy with a geologist's training in the authority of a SAWS audit committee member, says she was misled concerning the Vista Ridge pipeline source aquifers. This is a red flag. She was misled. Second of 3, we recently found SAWS CEO Puente leading a sub rosa brokering of transferable Edwards Aquifer water leases. Governor Abbott vetoed House Bill 1806 in 2019 to prevent SAWS from selling Edwards Aquifer water outside the Edwards Aquifer Authority's jurisdiction, but contrary to the Abbott directive, Puente's Exhibit C, included in the material that's been distributed to you, that memorandum of lease of groundwater requires only approval by a single lessee, Robert R. Puente. No approvals by the SAWS Board of Trustees, City Council, or any other governmental body. Conventional contracting practice was violated by this maneuver. Why? SAWS originally projected a Vista Ridge pipeline capacity of 55,000 annual acre feet with 15,000 annual acre feet of excess water to be sold. Now, 2 years after commencing Vista Ridge pumping, Puente is acquiring more Edwards Aquifer water with no explanation. Puente's presentation at the September 29th, 2022 City Council meeting included a slide 3, quote, recent addition of 50,000 acre-feet of firm water supply, close quote. Our sales of transferable Edwards Aquifer water leases and the addition of 50,000 acre-feet of water, both part of Puente's unilateral strategy? Does Puente need another 50,000 acre-feet because the quantity and or quality of Vista Ridge water pumped from the Carrizo-Simsboro aquifers has not met expectations with dim prospects for the future? What of Carrizo-Simsboro aquifers outputs that justified a $3.4 billion Vista Ridge pipeline investment? Should Puente not be required to explain what appears to be a bait and switch? To what locations will the ultimate recipients of transferable water rights convey the water? For what purposes will the water be consumed? This subterfuge validates Trustee Hardberger's concern for a Puente cover-up. Third of 3, you may have witnessed former State Representative and Attorney Puente state before the Committee on Natural Resources of the Texas House of Representatives on August 24th that the Vista Ridge project has, quote, buy-in, unquote, from the area the water is coming from. Testifying landowners later in the same meeting challenged Puente's deception, quantifying damages they had actually experienced. The American Bar Association advises, quote, a lawyer should be mindful of deficiencies in the administration of justice and of the fact that the poor and sometimes persons who are not poor cannot afford adequate legal assistance, with particular application to a prior case you've adjudicated.
And Mr. Mitchell, I'll ask you to finish your thought. Your time expired, but go ahead and finish your thought, sir.
One sentence. I look forward to your response. Megan Talk, your very helpful, capable staffer has my contact information. Thank you for your patience.
Thank you, Mr. Mitchell, and thank you again for being here.
Thank you.
And we have one other person who wishes to address the commission on this item. Ms. Smith, who is that?
It's Mrs. Lee Santos, and she is virtual.
Ms. Santos, are you with us?
Yes, sir.
We're receiving you
me?
loud and clear, so go ahead when you're ready. Thank you.
Thank you, sir. I have a question. I am a YouTuber and a social media influencer on Twitter and also a real estate investor in Port Aransas. And recently I was alarmed when I saw that the CEO of the Port of Corpus Christi, Sean Strawbridge, he was quoted as saying that we're definitely a target to the Russians because of our location and oil on Yahoo Finance. And I'm curious, what did he mean by that specifically, and why haven't the residents of Corpus Christi and Port Aransas been notified of a potential Russian threat, if there is one? And if there is one, why is he pushing for a development of a desalination plant on Harbor Island? First an oil depot and now this, so we've got to figure out why. So what I'm doing is to let people know that a Nord Stream pipeline was recently hit by Russians. It's still leaking. NATO believes it was sabotaged by the Russians, and we are at great risk on Port Aransas Island, or Mustang Island, because of the bridges that connect the mainland to the island. And we only have two ways on or off this island. One, those double bridges, and the other one is the ferries. So we've already been targeted since World War II by the Germans, who were trying to get in to the port with submarines to blow up the oil refineries. And there's nothing stopping the Russians or Putin, since we technically, there is a war, and like it or not, we're involved. So none of us want to be targeted, and we don't want to create any more of a target situation by creating any new developments in the Harbor Island area, which is only 5 minutes from my house in Old Town Port Aransas. So that's all I have to say. We want to know what's going on with those threats, if there really are any, and why are we building out there if there is. And thank you very much for your time.
Thank you, Ms. Santos. We appreciate your comments. I guess, just in response, for context, I understand your concerns about the infrastructure, and those are kind of really outside of what we do here. What our function as a commission is to, in these formal meetings, is to hear evidence, to hear comments, and take final action on rulemakings, permits, and enforcement cases. So we're not here in a forum to interact in terms of answering questions, although we certainly ask questions, and our jurisdiction doesn't extend to the concerns that you've raised, although they are understandable, and we appreciate you participating in the public comment session. So thank you for joining us. Ms. Smith, is anybody else signed in to speak?
No.
Okay. I guess we can return to the last set of items, and I think we're going to have to immediately go into a recess to hash that out. Or actually, let me just open it up.
Well, so to clarify, I'll recall that we're
yeah,
back
let's do that.
to
Recall,
20
and then I'm going to put
items.
a question. Yeah, go ahead.
Yeah, back to items 20 through 23, which is the consideration of new subchapters for Chapter 112 and the adoption of the Howard, Hutchinson, and Navarro County SIPs for the 2010 SO2 National Ambient Air Quality Standard.
So, Ms. Salem, you understood my concerns. What are your thoughts?
Well, I'm not sure I understand your concerns exactly. So what I thought you wanted to target was the requirement to provide notice. There are essentially two kinds of notice that are required to be provided. The executive director is required to provide notice that an AMOC has been requested, essentially. And then the applicant for the AMOC is required to publish notice in accord with the requirements for public notice format in subsection 6. So I was thinking you were focused on the requirement to publish notice by the applicant of the AMOC. If that's the case, then you could more carefully target that sub-requirement if you want to do that. You could just remove the waiver requirements completely, which would be a deletion of 112, 102, I2B, and the parallel other provisions. But I want to make sure that I'm understanding correctly. Are you trying to target all notice, or are you trying to only target that applicant publication of notice?
I understood these rules waived certain notice and comment requirements in connection with the AMOC applications.
So if you look at the rule language within what is one, for example, let's just take the first opportunity. 112.102 I2B says you can apply to the AD for a waiver of portions of paragraph 5 and 6. Paragraph 5 is the procedures for an AMOC plan approval. So within 5, there are subparts that require certain actions be taken if preliminary determinations to approve or deny have been made, right? The beginning text in 5 says that once you have a preliminary determination, then the ED has to provide notification to EPA, local air pollution jurisdictions, et cetera.
And we want to make sure that that notice is given.
Okay, so you do not want to exclude that. So you want that to always happen, no waiver for that.
Right.
If you look at subsection 5C, this is the requirement that requires the applicant to provide published notice of their intent to obtain an AMOC. You do not want that to occur.
We do not want that. We want that to occur. We want that notice. We want both notices to occur. We do not want that to be waived.
We don't want the ability to have a waiver.
Of that, right.
Is that?
We
I
do
mean,
not want the ability to waive the public process.
That's right.
Yeah, the
So-
notice.
So if you only want to exclude from the waiver opportunity 5C, then we could simply say in B, they can apply for a waiver of portions of paragraphs 5 and C, except 5 and 6, except for the provisions of 5C.
Okay.
If that's all you want to not allow.
All right. I think I understand what you're saying. I think I also need,
But you need to look at everything within 5
right.
and make sure that there's nothing else that you want to be sure always happens.
so
Right.
what, under what you just read out, what waiver would be available? What would they be applying for?
So, that's why we kept going back to, do you want everything to always happen? If you want everything to always happen, the other stuff within 5 are the notices to EPA, for example. You know, for the requirement for us to prepare a response to significant and timely written comments. And then there are written notices of determination. So that's why I was asking, if you really want all of those notices to occur, then I think that what probably you need to do is delete all of B, which allows for the waiver at all. So I just think we need to better understand, you know, what your concern is.
That-
Okay.
I'm good.
Commissioner Janeka, anything else?
I expect we might hear from prospective applicants who would want to utilize that waiver option. And I think that you're landing exactly on the crux of the disconnect or the concern is the language simply states in the rule that an AMOC, alternative means of control applicant may apply to the executive director for a waiver of portions of paragraphs 5 and 6 of the subsection. I think the concern is that could an applicant come up and apply for a waiver of that entire public notice portion, request, have reviewed and considered by the executive director, and say also waive the portions of submittal to EPA. I don't think that our agency staff would find that a credible path forward, but I agree, Chairman. I think you raise a very good point. And as former, having sat in the row of seats with technical staff opposite applicants requesting things, when our rules simply state, you may ask, it becomes a unfortunate cudgel that we get to face in the meetings where the applicants are expressing what flexibility they need up against the public's expectation to be told about it. So I appreciate the suggestion that we tailor that and try to cabin in what waiver they can get. I'm good with taking that out entirely, and we'll wait and hear from what flexibility is needed when these come forward.
Thank you for that. Colleagues, I need a sidebar with council, so
Same.
I'm going to propose we begin with a 5-minute recess.
Sounds good.
Okay. Time's 10:57, and we are again in recess. Okay, we're back on the record after a short recess. Time's 11:02, and I think what I'm going to suggest is that we just delete those three sections and not try to tease out. I think you had suggested that as an alternative.
Yes, sir. The other thing I did want to point out, John Mentor is participating virtually. He did note that there is section-by-section discussion on this point about the waiver. We also will need to look at further within the preamble to make sure there's no other, references that we'll need to remove.
Okay. All right. What I'm going to attempt to do is lay out a motion and.
Can I ask one? Can
Yes.
we, I don't know if we can do this or not, but can we get OPIC's thoughts on this? Or if we've already let them weigh in once. I don't know.
I think it's a wonderful idea. Ms. Mehta.
No pressure.
Yeah.
OPIC supports the idea of having the option of the public notice. OPIC supports that idea. Thank you.
We could have predicted that.
Yeah. Thank you, though.
Thank you, Ms. Mehta.
Well, I'm willing to hear your proposed, you want to make a motion? Since I made a motion, do I need to
No,
pull
I
it
think
back?
that one was never seconded.
That's true. It wasn't seconded, so.
I think we're ready when you are.
I will attempt. Okay, try this again. I would move that we adopt the attainment demonstration SIP revisions for the 2010 SO2 Howard County, Hutchins County, and Navarro County non-attainment areas and new subchapters E, F, and G of 30 Texas Administrative Code, Chapter 112, with the following revisions. That we remove proposed sections 112.102 I2B and 112.232 K2B and 112.302 C2B, and that we revise the preamble to be consistent with this removal.
I second that motion.
All right. The motion's been made and seconded. Any discussion?
I take comfort in this change going forward, given how difficult it sounds like the discussion and getting to this point has been. And I appreciate staff's work in getting us there. I think if we, I'll just say that we may find that our agency regrets not having flexibility in the rules, but frankly, where applicants, respondents, entities we regulate are willing to meet us halfway and provide what we need, regardless of if it's in the rules or not, regardless of going above and beyond. I think that really speaks to the general level of comfort of how much we expect it to be made more efficient and given opportunities for efficiency in conducting our programs, or forced to perpetually have to re-argue the need for a minimum threshold. And I think that this is a point where I find much more comfort in removing the flexibility at this point in our rule process.
Thank you, Commissioner Janeka. Anything else?
All I would say is, I should have said this earlier, but I appreciate all the staff's work on this. I think it's been, all of these are a big burden, but this one just seemed very tricky, and I think y'all put a whole lot of time and effort into it, and I'm very appreciative of it.
I'll ditto that. So with that, the motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
Items 25 through 28 are for closed session. The commission will meet in closed session in Building E, Room 211S. Do you want to go straight in, 5 minutes? At 11:08, as permitted by the Open Meetings Act, including Texas Government Code Sections 551071 and 551074, to take up and consider matters pursuant to items number 25 through 28 as posted and noticed.
The time is 11:07. We are in recess. Parson sip language from the dais. Thank you, Mary.
The commission met in room 211S in Building E for closed session from 11:09 until 11:20 a.m. on item numbers 26 and 27 as posted in notice pursuant to the Texas Government Code, Section 551.074. No action was taken. This agenda stands adjourned. The time is 11:22.